Dear learners, I welcome you all to this course on understanding human rights. So far, we have discussed in our previous lecture the meaning, nature, definition, significance, classification of human rights. After that, we discussed about the evolution of the concept of human rights from Magna Carta to the International Bill of Rights. That is, of course, the Western tradition of human rights. After that, we also discussed about the debate of universalism versus cultural relativism, that Eurocentric or West-centric human rights narrative or discourse should not be accepted. There are people who say that the non-Western perspective are also equally important. So we discuss about the non-Western perspectives of human rights. In the non-Western perspective, we dealt with Hindu perspective of human rights. Then we discussed about the perspective of Buddhism on human rights, and then lastly we discuss what is called the Islamic perspectives on human rights. Now, after this, we are going to explore the important theories of human rights. When I'm saying or qualifying the statement that the important theories, there are many theories, and I will say all theories are important. But again, as we have to wind up our course in a limited period of time, so that is why we have included only 4 theories under this theories of human rights. They are the natural rights theory, the legal rights theory, the historical theory of rights, and the Marxist theory, or you can say views of rights. Why I have mentioned the Marxist theory or views of rights? Because there are many who say there is nothing like Marxist theory of rights. There are many Marxists who believe that human rights itself is a bourgeois construct. So that is why theory oblique views of rights we have mentioned. Let me introduce these theories and what we are going to do this week. This week we will explore 4 prominent theories of human rights. I'm sorry that 3 theories we have mentioned here. We will explore 4 prominent theories of human rights, that is natural rights theory, the legal rights theory, and the historical theory, and then the Marxist theory of rights. So you have to make a correction. It is also including the historical theory of rights. We will examine each theory's core principles, strengths and weaknesses, and implications for understanding and upholding human rights. So before we venture into explaining these theories, it is pertinent to know why they are important not only for understanding human rights, but also for the normative justification of human rights. When I say normative justification, it means that human rights are legitimate or not. Our claims to human rights is justifiable or not. For that, you need justifiable theories, narrative, discourses, and that's why these theories are important. For example, when we are going to explore the theoretical aspects of human rights, what should we know that right from the very beginning, right from the classical Greek political thought, if we see, what should be the relationship between humans and their institutions, that is state and society, or you can say city-state in the Greek days, or the medieval Christian state, or you can say modern nation state today in today's world. So what should be the relationship between humans and their institution, that is a state and society, or between a state and society itself, has been the perennial question in political science. This underpinning and churning have produced many theories relating to a state, society, and their relations with the individuals comprising them. So, for example, during the Greek city-states, there was nothing like the concept of rights. Why? Because the city-state was everything. City-state was society. City-state was also installing God, which God should be worshipped. City-state used to define. We'll also find that the organic view of the state was there, and the human beings were not conceived away from the estate, city-state. City-state was everything for them. So, when in the medieval times we saw that the divine origin theory and other theories were there, we will discuss all these things. These theory, why we are discussing these theories? These theories help us better understand social and political institutions in their historical and epistemological context. That is why, that the legitimacy of the claim of the individuals, that they claim certain rights against the state or against, the the collectivity like society. So, how these claims are justifiable, that we will try to understand in the light of these theoretical justifications. So, for example, the organic theory of a state, the divine origin theory of the state, the social contract theory, and the evolutionary theory have implications for human rights claims. So, these theories, when we are trying to analyze, we have to see that they have their implications for our claims to human rights. Therefore, some important theories of human rights have been selected to discuss in this course. I hope it will help the learners to develop a perspicacious understanding of human rights, their origin, and their normative justification in the light of these theories. By understanding the nuances and the differences between these theories, we can gain a deeper insight into the philosophical and legal foundations of human rights. What are the philosophical and the legal foundations of human rights? We will understand when we are going to distinguish these theories, the differences, nuances, all we are trying to understand here. This knowledge will enable us to critically analyze the various approach to human rights and contribute to the ongoing discourse on the legitimacy of the claims to human rights. So, the first of all, we are going to take up natural rights theory. I am going to read, these words. They are very, very important. Men are born and remain free and equal in rights. Men are born and remain free and equal in rights. The French Declaration of the Rights of Man and of the Citizen. This is highlighted, and this has been taken from there. So, in the 18th century, you see what is happening, that the men are born and remain free and equal in rights. That is being claimed. Another important statement that you have to see, all human beings are born free and equal in dignity and rights. All human beings are born free and equal in dignity and rights. Article 1 of the Universal Declaration of Human Rights. We have discussed about the significance of the UDHR, that it was called the Magna Carta of Mankind, and this declaration, that is the Universal Declaration of Human Rights, which was called the Magna Carta of Mankind. Article 1 of this particular declaration, proclaims all human beings are born free and equal in dignity and rights. The inspiring words mentioned in these significant human rights milestones originate from the natural rights theory. This is a position that the people, those who believe in natural rights theory, they will take this position that men are born and remain free and equal in rights. Or all human beings are born free and equal in dignity and rights. In the natural rights theory, we find that it postulates that rights are inherent and universal. They are natural and they belong to all individuals simply by virtue of their humanity. So human beings, they are born with certain inalienable rights. These rights are pre-political and pre-social, existing independent of any government or legal system. These rights are, when we say these rights are pre-political and pre-social, so it means these rights existed even when the state had not come into existence, or even the organized living, even the society had not come. Pre-social, it means, the society in our modern sense of the term was not existing. So these rights are pre-political and pre-social, existing independent of any government or legal system. So if a human being is there, he has certain inalienable rights, and they are natural. They were recognized, they were accepted. It has a strong faith, the natural rights theory, it has a strong faith in the rational faculty of man. According to this theory, man is endowed with reason and conscience, and he is capable of regulating his behavior. The trust or the faith in reason or the rational faculty of man, that is a perennial feature of this particular theory. What is being emphasized? That the human beings are rational creatures. Since they are rational, they know what is good for them and what is bad for them. They also understand what are the rights of others, what they should do and what they should not do. Because of the conscience and the reason they have been endowed with, they are in a position to determine all these things. So that is why you will find under this theory that is going to make a very strong foundation for the claim to natural rights, that is the rational faculty of man and the reason they have been endowed with, or the conscience they have been endowed with. Since the human beings are rational, they have been endowed with reason, and they are able to determine what is good and what is bad, what is right and what is wrong. So therefore, this man should be allowed to act according to his free will without any external restraints. This man who is rational, he should not be restricted, because he knows what he should do and what he should not do. When we are trying to understand this natural rights theory, we should try to understand it in the light of the best exponent of the natural rights theory. And John Locke, who was a social contractualist, an English political philosopher, he is the best exponent of the natural rights theory. Now we are going to analyze Locke's position on natural rights. And before that, we have to understand his theory of social contract. As we know that all social contractualists, Hobbes, Locke, Rousseau, they believe that a state is a man-made institution. It is not a God-made institution, first of all. A state is an artificial institution created by human beings. They do not believe, like the Greeks used to believe, that a state is a natural institution, the organic view of the state. They do not believe that a state has a divine origin, or a state is a divine institution created by God, and the ruler is also appointed by God. The social contractualist, they believe that a state is created by human beings through a contract. And before that, when they are trying to explain that how a state was created, they say that there was a state of nature. The state of nature according to the social contractualist is a stage in human history when the state had not come into existence and people were living without any political institution. At that time, when the state had not come into existence, it was natural law or the law of nature that used to regulate their behavior. Thomas Hobbes, of course, he says that the state of nature was very bad. There was war of all against all. There was open cutthroat competition. And according to Thomas Hobbes, the life of man in the state of nature was solitary, nasty, brutish, poor, and short. But we find John Locke, who is also considered a father of natural rights theory, and was, of course, the best exponent of the natural rights theory. He says that the state of nature was a stage when the state had not come into existence, but at that time, people were governed by the law of nature or the natural law, and they're enjoying a very good life. The state of nature had peace, and the mutual goodwill was there. Since the human beings are rational creatures, so that is why their reason was there to guide them. How should they live? So that is why there was no, war or violence at that time. Rather, love, sympathy, compassion, mutual goodwill, all these things were there. And everybody was respecting the rights of others. According to him, according to John Locke, that in the state of nature, when the people were living in the state of nature, they were endowed with natural rights, the rights that are natural. And according to him, three important rights were given to them, or the three important natural rights were available to them in the state of nature. And that was number one, right to life, number two, right to liberty, and number two, right to estate, or right to property, we can say. So the three important natural rights were available to the people. That was right to life, right to liberty, right to estate, right to property. But what happened in the state of nature, people were, because of these three rights they were enjoying. So if the people have right to life, so it means that everybody was respecting the rights of others. So that is why the right to life was not violated. Right to liberty, the freedom of others was respected, because there was general understanding that we all have a right to liberty. And then right to property. So there was nothing like loot and plunder, because that understanding was also there because of the reason and the conscience that the people are endowed with. But what happens that there was a kind of uncertainty. Sometimes, since the law of nature or the natural law is vague, ambiguous, so just how it should be interpreted, that used to lead to some kind of conflict. But the people were able to resolve that conflict by reason, by applying their reason. So that is why, but sometimes this kind of problem used to arise in the state of nature. So that is why the people wanted that these rights that they were enjoying, that is in the state of nature, and that was responsible for making it a very happy state of nature, that is right to life, right to liberty, and right to property. So that is why they wanted to make it permanent and perpetual, everlasting. And for that only, they created government or a state whatsoever. We are not going into that detail whether it was a one contract or two contract, and the scholars have tried to analyze that it was not a social contract, rather it was a political contract. We are not going into that detail because that is uncalled for here. But you see that he is saying that a state is created or the government is established, that is for the preservation of these rights only. So what is the logical justification of the continuance or the establishment of the state? That is the preservation of these three rights, three natural rights, that is right to life, right to liberty, and right to property. According to him, these rights are inalienable, natural, universal, absolute, and sacred. They can neither be taken away nor be restricted by any authority or any circumstances whatsoever. So it means, these rights are sacrosanct. They are universal. They cannot be taken away by any institution. He identified these natural rights as, we discussed, that right to life, liberty, and estate, that is property. And interestingly, he gives the right to revolt against the government that tries to infringe upon these inalienable rights. The government, what is the contract is between the people and the government, between the ruler and the ruled. And the contract, one of the most important condition of the contract is that the government will promote and protect these rights. So since the estate or the government has been created to preserve and promote these rights, so that is why the moment government, the ruler tries or the ruler tries to snatch away these rights or take away these rights, it means that people have every right to revolt against the king or against the government. Why? Because that is the breach of the contract on the part of the ruler. Because the contract was between the ruler and the ruled, and the condition that was imposed upon the ruler was by the people that the ruler will try to promote these rights and preserve these rights. So that is why the government cannot take away these rights, that is right to life, right to liberty and right to property. So that is why he becomes a revolutionary political philosopher in this sense. Again, not only John Locke, one of the best explanations and justification of this theory is also found in the famous book by Thomas Paine, The Rights of Man. Very, very important book. Thomas Paine believed that men have certain inherent rights, and these inherent rights include freedom of conscience or religion, freedom of expression, speech and expression, and freedom from persecution, etc. According to him, these rights cannot be compromised or taken away by any authority. The rights identified and promoted by the natural rights theory form the foundation of many legal systems and are considered essential for ensuring the dignity and autonomy of individuals in society. This is the major contribution. Now we are trying to highlight the contribution of natural rights theory. So one of the major contributions is the rights that are identified, claimed and promoted by this theory form the foundation of many legal systems and are considered essential for ensuring the dignity and autonomy of individuals in society. So you'll find almost all the constitutions of the world, they have incorporated right to life, right to liberty and right to property in the constitutions, in their respective, in all the countries of the world. So that is why, this is one of the major contributions of natural rights theory. It also provided a powerful philosophical basis for challenging the tyranny and demanding individual rights. Again, important. So, the tyrannies, or you see the absolutist kingship, monarchies, they were overthrown. Why? Because the people were fascinated by the slogans that were raised under the natural rights theory, that right to property, right to life, right to liberty is sacrosanct. So that even the rulers who tried to snatch away these rights or those who tried to infringe upon that right, these rulers were declared as unjust. So it provided a powerful philosophical basis for challenging tyranny and demanding individual rights. Again, the notion of rights as natural resulted in great revolutions like the French Revolution and the American War of Independence. You see that the rights are not the gift of a state. Rights are not something, a kind of concession given by the state. Right is not something that is on the mercy of the ruler. This kind of view was championed or highlighted or promoted by this theory. So that is why this notion that rights are natural, and what kind of rights? The rights that is right to life, right to freedom, or right to hold property. These are natural. So what happened? This particular kind of position gave birth to many revolutions. So this natural rights theory is responsible for French Revolution, for Glorious Revolution, or for what we call many other revolutions, American War of Independence, American Bill of Rights, French Declaration of Rights, all. This is, this natural rights theory has been proclaimed when they are saying that human beings are born free and equal. Another important contribution is that natural rights theory played a significant role in the development of democratic principles and the concept of individual rights that are enshrined in many modern constitutions. Now, the critical appraisal, we are going to deal, what is the criticism of this theory? This theory may, sound very impressive and a theory that is giving us moral justification to claim rights, but at the same time, this theory has been criticized by many. The first criticism of the natural rights theory is that the natural rights promoted by this theory are difficult to identify and justify. When we say that these rights, right to life, right to liberty, or right to property, or other natural rights that are claimed, it is very difficult to, justify and identify them in the light of the law of nature. Again, it is dependent upon the natural law, which itself is vague. Natural law suffers from ambiguity. It is vague. So that is why it becomes very difficult to identify these rights in the light of the natural law. Jeremy Bentham, the father of utilitarian school of thought, famous English philosopher who is known for suggesting legal and political reforms, he comes down heavily on natural rights theory and says that natural rights are simply nonsense. Natural and imprescriptible rights are, according to him, rhetorical nonsense and nonsense upon stilts. He also says that the so-called moral and natural rights are mischievous fictions and anarchical fallacies that encourage civil unrest, disobedience, and resistance to laws and revolutions against established governments. It seems that he himself is conservative, so that is why, the resistance to laws and revolution against established governments. So, he's trying to criticize this theory on the ground that, this theory is going to instigate people, or, the natural rights, that they are mischievous fictions and anarchical fallacies that encourage civil unrest. Because you see, civil unrest, when the people are going to resist the law, which they believe is a bad law, a draconian law, a black law. For example, in our own country, the civil disobedience movement during the time of freedom struggle, because we believe that there were many laws that were opposed by Mahatma Gandhi and the great leaders of the freedom struggle at that time. So, for example, if for example, any kind of law that is trying to promote apartheid, any constitution that is going to follow racial discrimination. So ultimately, if that kind of law is being opposed, that cannot be called that it is going to create public unrest. So here you'll find he becomes conservative, but he is criticizing that natural rights, the so-called moral and natural rights, are mischievous fictions and anarchical fallacies that encourage civil unrest, disobedience, and resistance to laws and revolutions against established governments. Again, this theory fails to recognize the logical and moral relations between rights and duties. It is emphasizing on rights, but what about duties? We have already discussed that rights and duties go together. Lack of clarity on how to enforce and protect natural rights in practice. This is again important. The natural rights, for example, if there are certain rights that are natural, they cannot be implemented unless they are recognized by the society and they are becoming the part of the law of the land. So we can claim that our rights are natural, but if they are not accepted by the legislature and if they are not being made the part of the constitution or the law of the land, then these rights cannot be implemented. So that way, this is the problem with this particular right. Critics also argue that the concept of natural rights is subjective and open to interpretation, making it difficult to reach a consensus on which rights are truly natural. For example, when we say that the man is born free and equal, this has been criticized by many Marxist scholars. For example, man is born free and equal The moment man takes birth, he or she, becomes what is called the slave of natural forces like hunger, like thirst. Again, man is not born free and equal. Why? Because a man who takes birth in a rich family, a well to do family, in a developed nation, whereas a man who takes birth in a family that is suffering from poverty, starvation, so you cannot say that man is born free and equal. This kind of criticism have been also made. Additionally, the universality of natural rights can be contested, as different cultures may have different values and priorities. So that is why we find that the great debate in human rights, that is universalism versus cultural relativism. Finally, natural rights theory does not provide clear guidance on how to translate abstract principles into concrete actions and mechanism for ensuring their protection. This is another criticism. So it means that the law is very, very important, and the natural right, they may be claimed, but ultimately, unless they are recognized by the law of the land, they will not be implemented. So that is problematic. In conclusion, what we can say, that despite its weaknesses, that the natural rights theory suffers from, it cannot be denied that it provides a strong moral foundation for human rights, independent of the whims of governments. It also offers a universal standard for criticizing human rights abuses anywhere in the world. It means that the natural rights theory, it develops what is called a universal standard or the parameter to judge the performance of the governments and the states on accounts of human rights violations and protections. It also empowers, this theory empowers individuals to claim their rights and resist oppression. Again, natural rights theory has played a crucial role in advancing human rights globally. There is no doubt in it. It has inspired social movements, produced international human rights instruments, and continues to provide a powerful rationale for defending individual dignity and freedom. So, with this, we conclude our lecture on natural rights theory. In the next class, we are going to deal with other theories of rights. The three important theories now we have left. One we have already covered, and the three important theories that we are going to take up one by one. Number 2 will be legal rights theory. Then number 3 will be the historical theory of rights. And the fourth one will be the Marxist theory of rights. Thank you very much.